Morning, please be seated. We have two cases for argument this morning. In petition for disciplinary action against Michelle MacDonald and Curtis versus the state of Minnesota. We'll take the discipline case first. The record should reflect that Justices Lohawk, Hudson, and Chudich are recused, and Justice Dietzen is here back with us to participate in this case. Ms. Humiston, you've reserved 5 minutes for rebuttal.
Yes, Your Honor.
You may proceed when you're ready.
May it please the court, counsel, and Ms. MacDonald. My name is Susan Humiston, and I am the director of the Office of Lawyers' Professional Responsibility. This matter presents 2 issues, the first of which is whether the referee clearly erred when she found and concluded that respondent violated 7 ethics rules over the course of 2 family law matters, and whether a 60-day suspension with 2 years of probation with a mental health evaluation is the appropriate discipline for this misconduct. Now, the referee made 139 findings, 8 conclusions of law, conducted a 2-day hearing on this matter, and reviewed 93 separate and extremely voluminous exhibits. Each of the findings and conclusions are well supported in the record. The referee did not, however, when taking into consideration the discipline that she was recommending to this court, take into consideration 3 rule violations. That's the conduct that led to the sanctions in the Grazzini-Rucky matter, and the failure to perfect appeals in both the Grazzini-Rucky and DaCosta matter. Because the referee, having clearly found rule violations but did not consider them in making a recommendation, the director believes that a 90-day suspension is warranted by the facts of this case. Now, respondent may—
Counsel, before you go off of that, does the referee have the discretion to not apply misconduct or not discipline for those rule violations that you just mentioned? In other words, it seems to me that you're arguing that there were these rule violations related to the subpoena, the failure to appeal, that the referee didn't consider in determining the amount of the discipline. Didn't the referee have that discretion?
The referee does have discretion in determining what the appropriate discipline would be. I would suggest and this court gives great weight to that recommended discipline. I would suggest, though, that the referee gave insufficient consideration to the cumulative nature of the violations by failing to take into account the harm that was caused by those 3 rule violations, which suggests that this court might want to not accord such great consideration, great weight to the referee's recommendation. It's a factor that the court, I suggest, should consider when determining whether or not great weight should be accorded.
Counsel, can I ask a question in regards to, it's my understanding that in reviewing the referee's findings, that there was originally a citation for contempt of court, which was subsequently dismissed in the criminal proceeding. And there was also a citation for obstruction, also in the process, which was also subsequently dismissed. But am I correct to say that that was never petitioned as a rule violation regardless of the outcome of the criminal case? And I would also ask about the events from, let me get the right date, from the April 2013 events in Rosemount, where Ms. MacDonald was also charged with obstruction, and that of which she was found guilty and was affirmed at the Court of Appeals. Am I correct to say that that has not been a part of any of the disciplinary actions? And if so, why not?
So you are correct. The 2 misdemeanor charges that were subsequently dismissed did not form a basis of any petition by this court or by the Office on Discipline, nor is the other matter that you referenced. The director considered those issues, but chose not to, given this court's prior considerations of misdemeanor charges that have not been, where there has not been a conviction.
But there was a conviction in the 2000, excuse me.
And I'm not familiar with that, actually.
Sorry, I now have the light on. So April 2013, Ms. MacDonald was arrested and charged and convicted of obstruction of justice. And are you telling me that the director's office is not familiar with that?
No, I'm sorry, the director has not reviewed that matter.
Thank you.
I think in this matter, respondent takes issues with three aspects of the referee's order. The referee, in respondent's view, erred by not blaming Judge Knudsen for respondent's continued arrest and detention on the second day of the Rosini.
Excuse me, counsel, what's the director's office position about whether this court can consider the criminal conviction for obstruction?
I would say that would not be appropriate because respondent has not received notice that that is the basis of a rule violation, nor was there an evidentiary hearing on that matter. The second error that respondent alleges is that her First Amendment and her subjective belief allowed her to make false statements questioning the integrity of Judge Knudsen, and that the referee accorded insufficient weight to respondent's pro bono service. Now, as it relates to the arrest, each court who has looked at this matter, including the referee who viewed the videotape and heard the testimony around this, concluded that respondent was responsible for her arrest and her continued detention during the second day of trial. That all she needed to do was provide her legal name, which is different from the name under which she practices, her address and her date of birth. She would have been issued the tab citation, and she would have been able to go on about her day, representing Ms. Grzini-Rucki in the second day of trial. Respondent chose not to, and instead, as the referee found, considered what evidence she could. She took advantage of the situation in order to create an issue on appeal, garner a mistrial, and add counts to her federal lawsuit, instead, again, of thinking of her ethical duty to represent her client who is in the midst of a contested custody hearing.
Counsel, you mentioned the First Amendment defense, and I want to know what the director's best response is to that, in particular with respect to the allegations made against Judge Knudsen. But in general, any sort of response you have on the First Amendment defense?
So this court in 1990 in the Graham matter looked at Rule 8.2a and concluded that disciplining attorneys for making false statements that are knowingly false when made or are false and made with reckless disregard for the truth is consistent with the First Amendment of the U.S. Constitution. That is in accord with the New York Times versus Sullivan matter, but the court modified that test to make it clear that the test is really one of a reasonable attorney. It's an objective, not a subjective test, and that has been applied. This court has applied that since 1990 in a number of matters, and every state who has similar Rule 8.2a, which is based upon the model ABA rule, has consistently applied that rule to discipline attorneys who make false statements. That is not within your purview. Although we respect the First Amendment, we allow people to challenge people who are in positions of authority. You cannot make false statements. You cannot make false statements with reckless disregard for the truth or that are knowingly false. I think that it's important to focus on the specific fact statements that were made. These were not statements of opinion. And I think the respondent doesn't even actually say that they are not in fact false. She submits that it was her subjective belief that they were true. And again, this court applies very clearly in every case that it is looked at an objective standard. But what she said is that Judge Knudsen, among a number of things, he was biased against respondent since day one, or respondent's client since day one, that he conducted a pretend trial, that he signed orders he knew were false, that he used professionals to gather information that he knew was false, that he compromised MNCIS, the state's court docketing system, and he usurped case files in concert with opposing counsel. These findings are reflected in the referee's findings at paragraphs 42, 48, and 102. Respondent acknowledged during the disciplinary hearing that these are very specific and very serious charges that directly implicate the integrity of a judicial officer in this state. Now, respondent, when pressed for what was the basis for each one of these, she explained her theories, and as the referee found in paragraph 106, that no reasonable attorney would make these false statements on so little evidence. And in fact, the evidence was to the contrary in many different situations. And again, I believe respondent doesn't even argue that there was an objective basis for any of the statements. That's not what the disciplinary hearing was about. She really argued that she was most of these claims were made in the federal lawsuit. Her client verified them. She was able to rely upon what her client said to her. And because she did that, she had a belief that that information was supported. Now, we believe that it is true that
Counsel, why isn't that enough? I mean, you're supposed to represent your client, and so why isn't it enough that she asserted, at least under the First Amendment, asserted claims that her client apparently verified were true?
And there are many circumstances under which you can rely upon information that is provided to you by your client. And that would apply to, I think, the very first constitutional challenge that Ms. MacDonald made in the Grazzini-Recchi matter. She came in, she filed there, but when you are confronted with significant evidence to the contrary, that in fact disputes what you and your client believe to be true, you have an obligation to review that information. And you cannot then just rely on information that your client is telling you that is contradicted. I think the most telling instance of that is something that was seen even at the disciplinary hearing, where we were going through a transcript of a hearing that occurred on the September 7th, 2012 custody order, which is really the basis of Ms. MacDonald and her client's belief that there was a huge wrong that occurred in the Grazzini-Recchi matter. And Ms. MacDonald believed that that hearing had occurred without any, it wasn't on the record, that the order had been written by the opposing party's counsel, that her client had never said she did not want custody of her children. We're reviewing the transcript where each of those matters are refuted. It was an on-the-record hearing that was conducted by Judge Knudsen with Ms. Grazzini-Recchi's counsel of record present, who both parties, the judge and her counsel, recollected that Ms. Grazzini-Recchi had said she did not want custody of her children. All of these things are being refuted by the transcript of the hearing. And when I'm asking her about that at the disciplinary hearing, she said, well, do you want to know what happened? My client told me what happened. Who wasn't there, who didn't, again, she's still persisting in the fact that the facts are different than disclosed in a transcript that recorded an actual hearing that had taken place.
So your key, at least on the First Amendment, is the Graham standard, which is when or how we've subsequently interpreted the Graham standard, which is that when an attorney is confronted with overwhelming evidence to the contrary, that it's unreasonable to persist in continuing to claim the same thing.
Right. Okay. False statements, and that is the
Counsel,
definition, in my view, of reckless disregard for the truth or the falsity of what you are saying.
Counsel, having that in mind, I'm very concerned about one other portion of the referee's findings, and that is the aggravating factors. And it seems to me that finding 134, 135, and 137 directly bear on this rule violation, and it seems to me that the referee is double counting. In other words, it's taking, the referee's taking a rule violation and making it also an aggravating factor. Why am I wrong about that?
I think that in general, it is true that the findings that she continued to blame others for her own misconduct was considered an aggravating factor by the referee, that her failure to have insight into how her actions affect others was considered to be an aggravating factor, and that her inability to continue to acknowledge facts by the court was considered an aggravating factor. And while there is some overlap with the reckless disregard piece, the referee's findings go to all of the misconduct in this matter. At the time of the hearing, Ms. MacDonald would say, and she testified to things like, "Whatever I did wrong, I'm sorry." That's not relating just to the Rule 8.2A violations, but it goes to all of the misconduct here that was alleged. So I would suggest that it's not double counting, but is in fact taking into consideration deeply troubling aspects of her failure to understand her ethical obligations to her clients, and to understand how her conduct caused harm to others.
Well, it seems like, I know that we have said before that when a rule violation is found, that you can't take that same rule violation and use that as an aggravating factor. I don't know whether we have said whether you could have 3 aggravating factors that are the same and that's a problem, but it seems to me we have 2 issues here. One is the rule violation versus the aggravating factors, and then the second issue we have is 3 aggravating factors that sound, to me, almost the same. And if those are being separately counted to determine that that the discipline should be, in this case, 60 days, it seems like there's double counting.
Well, I guess I would disagree with the court in that the blaming others for her misconduct is not reflected in the Rule 8.2A violation. That was something that goes to her arrest, which is the Rule 1.1 and 3.5H, disrupting the court charges. And I think, again, it related to a lot of it, but it didn't play into the Rule 8.2A violation. Again, her lack of insight of how her conduct affected others is not an element of Rule 8.2A. Again, that's just an objective test of whether or not she made false statements with reckless disregard for the truth or falsity of those facts. There is some overlap in 137, the continued inability to acknowledge facts that are found by the court. That is why we were able to prove her lack, the reckless disregard in that matter. So I see the court's perspective from that, but I think it's broader than just the Rule 8.2. There, in every instance where we talked about information, and again, respondent would say to me during the disciplinary hearing when questioned, she kept saying that she was being disciplined for challenging the constitutionality of Rule 518. That was not part of any of the charges. It was a context that were there, but it wasn't part of the basis of the charges. She would not acknowledge that the courts had considered each of those constitutional claims in the matters and had addressed them she just wouldn't acknowledge facts. I think there are many that are outside that was needed to prove 8.2, which suggests that the referee appropriately considered that as an aggravating factor.
Counsel, I'm going to follow up on Justice Dietz's question. You know, between those three conclusions or findings, I think maybe two separate aggravating factors, and that is there seems to be a lack of insight as sort of the theme of one of those, and then also a lack of remorse,
Yes,
which kind of goes to the
others.
blaming of others, et cetera, et cetera. Can those two be separate? I mean, have we recognized lack of insight and lack of remorse as separate aggravating factors in our cases in the past?
Lack of insight and lack of remorse.
Seem to overlap.
No,
That's why I'm asking the
those are
questions.
essentially very much saying the same thing.
Okay.
If you cannot acknowledge the rule violation, you can't recognize remorse. And so when she says, "I'm sorry for whatever I did," that is not remorse because you're not acknowledging that what is the discipline that you're being charged with.
On top of continuing to assert that there was never, that all of these things happened.
Right. Again, I think it is important. I mean, I do understand Justice Dietz's comments about 137, but to me, that's also the most troubling aspect of this case. When we're having a hearing going through these things, to continue to fail to acknowledge contrary facts, or that even that there's a contrary perspective, shows a lack of judgment and a concern that I believe is appropriate to aggravate.
Counsel, before your time expires, could you speak to the mental health evaluation? What was the referee's basis for ordering that, and what is the director's position about that?
Now, the referee did recommend that sua sponte, and that it include a mental health evaluation, and that any follow-up be considered. The referee did not specifically set forth her reasons for that basis, although I can say, as a person who attended that trial, I understand the perspective of the referee, and the director does support that requirement, as within this court's Rule 15 rules on lawyers' professional responsibilities, ability to order it. I think that the transcript shows, again, a attorney who, when confronted with specific information that is contrary to her belief or a position that she has taken, she would not acknowledge those specific pieces of information, or that it even, you know, maybe we can agree to disagree. There was just no acknowledgement of that information. The lack of understanding, the continually shifting and blame. There was also some troubling instances in the record where she kept saying she was strip searched during her detention, when the video shows she clearly was not. It was a pat down, a very pro forma pat down in the holding area. I think as a person who was at that trial and reviewing the record, I suspect that is where the referee was coming from, and the director believes that does present a potential issue that should look in. I'm obviously not a psychologist, nor is the referee, but I do think it's a matter that should be evaluated by a professional.
But the director's office is asking us to impose that as a condition.
I am asking you to affirm that recommendation, yes.
Well, counsel, I want to ask you about that. According to my review of the case law, you're right, we do have the power to impose that. There's no question about that under the rules. But my concern is from my research, I only saw 2 times in history where we've imposed that as a condition, where the attorney's mental health was not at issue. The last time we did it was 16 years ago in a case called In re Fuller.
Yeah, Mr. Fuller.
And the other time was in 1989, In re Levenstein. And I'm wondering, I guess I'm concerned for 2 reasons. One, we don't do it very often. I'm wondering why this case might be similar in the director's view to that case. But secondly, given the lack of reasons in the referee's report, that also concerns me, and I'm wondering what the director's response is to that.
You're correct in your research. That's what ours turned up as well. And the Fuller matter is the most recent in 2005 where that happened. Mr. Fuller did not put his mental health an issue as mitigation. He had agreed in those circumstances to a voluntary psychological evaluation where he was diagnosed with a delusional personality disorder, which was then actually the court used to, against his wishes, mitigate some of his conduct in the Fuller matter. I do think it is unusual. It was not requested by the referee. All I can say is I believe that it is well supported in a review of the transcript of this matter. It is in the authority with this court. It should be used sparingly because I do think respondents should be able to put that issue, that matter in issue if they choose and to choose not to. But I also think because of this court's plenary authority to supervise and regulate those that hold attorneys' licenses, it's an appropriate exercise of this court's authority in rare circumstances.
Would we have to find facts, though? I mean, here's where I think I'm asking about, or why I was asking about the lack of reasons for the referee's finding. It seems to me that we would have to make some findings along the lines you suggested, where, you know, some of her statements at the hearing. And is that a problem for us to be making the findings that the referee maybe should have made in the first instance?
I think that because it's an element of discipline, that this court has they're the sole arbiter, and that they can, from the record, determine for themselves that it supports that determination. I think that the last thing I want to focus on with my time is the harm of these rule violations. I think on the one hand, it's easy to minimize the harm caused by respondents' misconduct, particularly criticizing the courts. People think you should be able to criticize the court. We're zealous advocates. I believe that's true. And I don't want to be seen as infringing on people's ability to be critical of the courts. But whereas here you have two clients, has the evidence submitted at the hearing demonstrated, they themselves already had contempt for the judicial process. Each of them were extremely angry and were not participating in the proceedings that were before the court in those two matters. When you have clients like that, the additional harm caused by a lawyer who makes false statements about the integrity of the judicial officer who is handling that custody matter, who demonstrates themselves contempt for that court by continually interrupting the court and not according it the respect that their client should be according it, and fails herself to follow rules, that really emboldens clients and I think causes significant harm, makes a very difficult situation worse.
And counsel, what about the fact that the conduct also delayed the proceedings?
Significantly. I mean, this was a custody in the Grazzini-Rucki matter that had been pending since 2011. Ms. MacDonald was not hired until 2013, but it was very hard to get to the merits, and Justice Knudsen testified a number of times at the hearing. He just wanted to get to the merits of the case and bring some normality to those children's lives. Again, the respondent violated 7 rules across 2 matters. I think that the director requests that the referee affirm, that this court affirm the referee's findings as it relates to the mental health condition. The office would request some specificity if the court is to adopt that term of probation, namely that a date by which an evaluation should occur, who will pay, and that the director must approve of that choice of healthcare professional. I think everyone would be served by specificity around that condition if it is imposed by the court. Thank you.
Thank you, counsel. You have 5 minutes for rebuttal. Mr. Eng.
May it please the court. Pauling on behalf and counsel. Pauling on behalf of Michelle MacDonald. She's a 30-year lawyer with extensive pro bono efforts in her community and the former part-time referee in Hennepin County. And this is the first time she's been before the court on a disciplinary matter. She raises, in my view, 4 issues rather than the 2 that my colleague has suggested. The first one concerns the efficacy of her arrest and how it was evaluated in the court below and by the referee below. The second relates to that and whether or not she has a First Amendment privilege to complain about her handcuffing during a trial in the Dakota County District Court, which was unnecessary and egregious and most unfair, and which gave the other side an unfair advantage. She has that right to complain and file an ethics complaint, no matter how it turns out. But we have an obligation, a First Amendment obligation, interpretation to allow lawyers to file complaints.
But Counselor, how do you respond to the referee's findings that the result of her being handcuffed was due to her own conduct?
Well, I completely disagree. The referee's finding is an error. The central finding is in paragraph 69, and that says that it's her fault that she was arrested, and the reason she was arrested is that she refused to give her name to the deputies who asked for it in the holding cell, and that's all on Exhibit 15. That's an error. She was arrested, according to the transcripts we presented, the moment she was led away from a public courtroom during a break. That's when the arrest happened. That wasn't her fault. That was the conduct of the deputies who were in the courtroom. She was arrested formally because her freedom was restricted by 2 or 3 rather substantial deputies. And it's not her fault that she was arrested for taking a picture of an empty courtroom when the judge wasn't even there. And the record is very clear, and I would like to read a couple snippets to you for emphasis of when the arrest happened. The transcript of the Sergeant Molston was introduced to Exhibit 9 for us, and it was also an exhibit for the director's case. Quotes, "During a break, I asked Miss MacDonald to come back with me to the hallway. She said she wanted everything on the record. She was not going with me. I told her she was under arrest at that point in time." That's the testimony. And then the testimony is also from the cross of Judge Knutson that this was completely needless, that she need not have been arrested. They could have gotten her name. The name was on the pleadings of the case. It was in the court record. There was absolutely no need for her to be taken back away into the catacombs of the Dakota County Courthouse to find out what her name is when they already knew it. And in case the record is not ambiguous, page 67 of the same officer's testimony. And so there's no dispute at that point in time you used the word arrest, so it was clear, and we can state for the record that she was not free to leave at that point in time. Is that correct? Correct. Okay. So we have, this is an outrageous situation here. We have a lawyer arrested during a trial, and this is a bigger case than Miss MacDonald's case. There is a symbiotic relationship between the bench and the bar. The bench, rightly so, demands respect and courtesy, and the bar, rightly so, does not expect to be humiliated by the bench, right? And in this case, the testimony of this deputy is quite clear that the judge knew very well she was taken back there for an order of the district court that she never saw that said you can't take a picture anytime in the courtroom, and that the deputy told the judge
Counsel, isn't it the obligation of a practicing attorney to know what the rules are of the court? I mean, every court has standing rules by the chief judge of the court for certain activities that can and cannot happen in the courthouse.
I agree with you. On the other hand, and what the referee didn't address, there was a conflict between the rules. There was a more stringent rule by this district court in Dakota County, and then there was the general rule 4.1, which he was familiar with. The testimony of the deputy here is that she was not shown that rule, and she interpreted the rule to say that while the court was not in session, she could take a picture. In any event, stepping back from this, why should someone be arrested? Why should a lawyer be arrested for taking a picture? There are lots of remedies that could have been
Counsel, why do we, what difference does it make if there were certain problems with the arrest or the detention? I mean, the problem I guess I'm having with your argument is I'm trying to figure out how it fits in. It's not a criminal case. This is not a criminal case. And so part of what the referee's findings were about were essentially her response to all of this, her response to, and that those things were inappropriate. And I got to say, even if I were illegally arrested, I'm not so sure I would have taken the same tact. In fact, I wouldn't have taken the same tact. I would have tried to cooperate. And so I'm just trying to figure out what all of this means and why you're making this argument here.
Well, it relates to the part of the discipline is that she writes these letters. Essentially, the discipline is the lawsuit against the Judge Knudsen as a private party, and she's disciplined for writing letters to the Board of Judicial Standards. And we're claiming as to those letters, which are not separated out in her discipline, but are referenced, are First Amendment protected because it's true. I mean, I would like to quote her letters, which are based upon fact, which I just told you about. The judge knew, in fact, the judge was aware she was in handcuffs. The judge was aware she was in a wheelchair. And the judge was aware that she was in a diminished state when she came back, okay? And she has a First Amendment right to complain about that. No lawyer should be treated that way. I don't care if you're Michelle MacDonald or somebody else. You can be obstreperous, you can be everything. You ought not be put in wheelchairs and handcuffs and rolled back into the court. It shouldn't happen.
Wasn't she put in a wheelchair, though, because she wouldn't stand up?
I'm sorry, I couldn't.
Wasn't she put in the wheelchair because she wouldn't stand up?
Yeah, but.
And they were trying to bring her back to the courtroom, but she wouldn't stand up.
Right, and so she was disabled. I mean, it's really a horrific video to watch, in my view, of a lawyer, you know, taking off your jewelry, take off your glasses, put yourself in a wheelchair, put a thing around your waist and be brought back. I mean, on the one hand, you can say, sure, I would have just told my name, maybe so, but she didn't. And the uncaused cause of this, the Aristotelian problem, is the arrest for a non-event. But the real problem here is that, well, there are two problems, is that she filed complaints that she's been sanctioned for with the Board of Judicial Standard. And she has a right to complain.
Counsel, is it your view that the First Amendment gave your client the right to tell lies?
No, but
what is your view of the First Amendment in this context?
My view of the First Amendment is that you have a right to engage in a good faith complaint against a judge.
And the good faith is evaluated subjectively or objectively?
Well, this is the great conundrum here now we have, because since...
It isn't a conundrum. I mean, haven't we said it's an objective test?
Yes, but we're talking about two different violations. We're talking about 8.2 and 8.4. The defense to 8.4 is a subjective good faith defense, and there's no defense to 8.2. And in the disciplinary recommendation, both are cited in the same paragraph. So it is a bit confusing, but she has a defense to 8.4. But what the ruling is...
Just to follow up with that, what do we do with the fact that the federal judge, the referee, and I think that might be it, but they all said variations of the word frivolous, without a basis in fact, et cetera. Those are very unusual words, I think, for federal judges, especially to use in a case like this one. So I'm wondering what we do with essentially factual findings by multiple judicial officers that essentially say there was no basis in fact.
Well, I've given you the basis in fact by reading the transcript here. And the reason the federal lawsuit was dismissed is that the immunity, judicial immunity, is very hard to overcome. And so, I mean, she had, I want to stay with this right to complain, though. I mean, if she writes a letter to the board, this is very important for not just for her, but for going forward here. I mean, can you write a letter complaining about a judge who arrests you? And she says in her letter of April 12th, which is in the voluminous exhibits here, that Judge Knudsen absolutely knew of my condition before he ordered them to return me to continue to trial. She complained about that. I mean, and then in another letter of December 26th, which was the first letter, she says Judge Knudsen claims he had nothing to do with it. The deputies arrested me. They brought me back to the courtroom in cuffs in a wheelchair with no eyeglasses, hairpiece, shoes, and I was made to continue my participation in this debilitated, humiliated state. It's a true statement. It's a true statement for her. Why isn't that protected? It's a public forum. It's a matter of public concern, and yet she's disciplined for this. And now, since Graham, the First Amendment law has been evolving.
Counsel, I confess I'm a bit confused. So you said earlier that there was a defense to the 8.4D.
Right.
For making false or statements in reckless disregard. And there's also the 8.2A.
Right, that's right.
And so let's focus on 8.4D. What is the defense to the finding or the conclusion that it is professional misconduct for a lawyer to engage in conduct that is prejudicial to the administration of justice? That's the rule, right?
Right.
Okay. Why is making false statements or statements in reckless disregard not a violation of 8.4D?
Well, technically it is, but there's a good faith provision now. If you look at Gentili versus Nevada case, they talk about the lawyer's good faith in the face of a provision much like this. And then you have the...
Well, if I drill down, are you essentially saying that you're asking us to overrule our prior precedent that this is an objective rather than a subjective standard? No,
I'm saying that you should look at your 20-year cases in light of the more recent Supreme Court law and also in light of Yagman, which affirms the lawyer's right to render an opinion that may be subjectively based, but an opinion nonetheless. I mean, that's a terrific case for the defense bar because he said all sorts of horrible things that were far worse than Ms. MacDonald ever considered.
Yeah, I'm just trying to drill down to make sure I understand what your argument is. And so are you asking us to overturn our precedent that this is an objective standard?
No, I think you should read it in light of the developing law. But no, I'm not. I didn't brief that. That's quite a high mountain to climb.
Counsel, one of the issues that runs through these proceedings has to do with, the duty of the lawyer. And I'm wondering what your position is on the duty of the lawyer to either consult with prior counsel about specific events or to review files and other written materials that were in the possession of prior lawyers. As I understand it, neither of those events occurred here. And I'm wondering what your view is on that.
Well, my view is governed by 3.1, which holds that you can, as a lawyer, engage in a good faith belief in the client's assertions to you. The rule does not say you have to consult with other lawyers. It may be a good idea. But in this particular case, Ms. MacDonald was the fourth lawyer. The other three lawyers had rather enormous fee liens on the file, which would only enlarge if she talked to them. And we have a client here who thought that she was being mistreated in the courts.
So let me pursue that for a moment. I'm wondering, given the pretty I'm trying to look, let's say the pretty strong statements that the attorney here made, given the fact there have been multiple lawyers involved in this case, if we assume our standard here is objective, doesn't a reasonable lawyer take a look at that file or take a look at those files or consult with a prior lawyer before making the kinds of allegations that were made here?
Well, she did look at the file. There was testimony that she spent a fair amount of time in Dakota County doing this, so she took care of that prong of your question. Whether she had to, as a matter of law, talk to the lawyers, I don't think there's a requirement that she do so.
But Counsel, was that the court file, or was that the file that the lawyers had, which would have obviously more information?
It was not the lawyer's file. It was the court file, right. I mean,
That's my question. What I'm trying to get at here, you know, I mean, I do think it makes a difference what the allegations are, and allegations here are awfully serious that she makes. And it seems to me that objectively, a lawyer would want more assurance, perhaps, than simply a client who has had some disputes with prior counsel. Am I right or wrong about that from an objective standpoint?
well, you're right, but the test isn't hindsight. The test isn't what you and I would do or someone else would do. I mean, the test is when faced with a client who's perhaps difficult. I mean, the children left here and were gone for several years. And makes these allegations, and there's been a complete breakdown with the lawyers, and the client tells you, the lawyer, that she was unaware of the hearing where certain findings were made and certain decisions were made, and never talked to her lawyer about the hearing, you can either believe the client or you can believe the lawyer. You could do one of the two. So let's say arguendo, going further in your question, let's say she does talk to the other lawyers, and they said, well, Ms. Rosini-Rucky is difficult. The representation she's making to you are not consistent with my memory of the case. The lawyer still has the choice, it seems to me, under 3-1 of siding with the client. I mean, this happens all the time in the practice.
But my point is, and now correct me if I'm wrong, but the director says some of these things could have been determined by reviewing the record and determined that, in fact, they didn't occur in the way in which the client asserts that they did. And so my question is, given an objective requirement that a lawyer reasonably investigate in some fashion, isn't that a problem here?
Well, she, on the flip side of that, you know, what a lot of lawyers do and what she did is make the client verify the complaint, okay? So one of her defenses is, look, we're going to file this federal complaint. We're going to try to puncture the immunity. We're going to sue the judge individually. All these things are very difficult to do conceitedly, rightly so. But you still have a right to try if you want to bend the law. And 3-1 says you can try to bend the law. You can change the law. I mean, this is what lawyers do. It just happens to be a judge in this case, which makes it extremely sensitive.
Counsel, to take it a step further, how do you respond on this point to the director's argument on page 24 of their memoranda, where they say, okay, even assuming the initial acceptance of her, the client's version of the events was a sufficient basis, once Judge Knudsen issued his April 2013 letter detailing the procedural history, which was at odds with the facts she argued, subsequent continued reliance is unsupportable. What's your response to that argument?
Well, maybe you can help me with what is, you're talking about an order from the court, or are you talking about a letter? Which one are you, refresh my memory on what you're talking about.
Well, what the argument is, the director is responding to the argument in which respondent argues she was entitled to believe her client,
right,
and that she had no basis to disagree.
Okay.
And so the director argues it in two steps. One is the step, the duty to inform of the lawyer to inform him or herself of the client's positions, which you were talking to or discussing with Justice Anderson, and now I'm asking you about her duty after she gets this April 2013 order that says, no, these are the facts.
Well, her duty at that point is to inform the client of the remedies available, which include an appeal if you want one. And if you persist in your position that's contrary to the courts, we'll appeal and persist in it. That's your obligation. I mean, you know,
Isn't it a
the
rule?
lawyer never takes sides here, Judge. I mean, the lawyer says to the client, here's your remedy. We lost. If you want to appeal, I'll appeal for you, provided we make arrangements and whatever. But you can still be persistent, and she is persistent by any standard, even in the face of an order. I mean, this is the nature of litigation. If the court disagrees with you, you ask for a review. And that's the remedy, I believe.
Counsel, I have the Nevada case that you referenced in front of me, Gentile versus the State Bar of Nevada, and I'm just wondering if you could point to me specific language in the opinion that you think helps your client's cause.
Sure. Well, that was, you know, the judge cuffed the public defender, and she complained that she couldn't advocate for her client in the cuffed state. She was obnoxious to the court and likely disrespectful. But he says, he waives his right to the allegations which are set forth here, and that's page 4. He agrees to consent to public censure, and he agrees on page 4 to not serve in a judicial position. And so the allegations are set forth that he countenanced, he had her arrested and cuffed. And there's an agreement, it seems to me as I read this, is that, you know, he violated the code of judicial ethics in Nevada, agreed to censure, and agreed to retirement. Maybe I'm missing your question, but that's how I read the opinion. I mean, it's really hard to find opinions where the lawyer's cuffed.
Well, maybe I misunderstood your argument. I thought you were suggesting that the United States Supreme Court in Gentile versus the State Bar of Nevada has somehow modified what we said in Graham about the test being objective. I thought that's what your argument was. Perhaps I misunderstood you.
Well, I think they modified it for a lawyer who gives a press conference in defense of his client who's been indicted, and he gives an opinion that the law enforcement people are lying. That's protected conduct. That's Gentile. So that changes the, I mean, he had a good faith basis to say that. It was subjective. It was not objective. And it was based upon what his client said. So I thought
You think that Gentile stands for the proposition that the test is subjective, not objective?
I think it changes I think it adds a good faith basis to it, which I'm trying to nudge the law here a little bit to good faith on the lawyer, but clearly the lawyer in Nevada was acting in good faith and couldn't be disciplined for what he did. And that was a groundbreaking decision because before that happened, you couldn't say a word. The other concern here, I'm running out of time, I had a couple points. If, let's say for the sake of argument, that Ms. MacDonald runs against Judge Knudsen, and under the Republican Party versus White, which is the Supreme Court case, she is allowed to take positions on certain issues, okay? And if she were to run against him, could she say, and I think she could, that this arrest was bogus, that I was treated unfairly, that the rulings were unfair, that he engaged in unethical conduct? And the question that I raise with you is whether that would be protected speech under that decision.
Counsel,
and I believe it might be.
Let me ask you a factual question. You started out the argument by talking about lengthy service by Ms. MacDonald and the fact that she has extensive pro bono work. And I want to ask you, And there seems to be some suggestion that that should have been a mitigating factor in your brief. And is that still your argument today?
Absolutely. I mean, it's the third, there are some cases from the court, that the law, that a great deal of experience doesn't matter because you should know better.
Yeah, and so my question is there's a finding by the referee that she still holds an attorney lien in the Grazzini-Rucky matter of $193,195 or $190.05. Does that undermine your argument for using pro bono as a mitigating factor? And I apologize for going over time.
Not really, because it'll never be collected. It's symbolic. I mean, I think it's symbolic compared to the, I mean, I think it shows she worked a lot harder than the other lawyers did who charged a lot and didn't even get to trial. So I think it's a symbolic act.
Thank you, counsel. Your time has expired. Ms. Humiston, you have 5 minutes for rebuttal.
As it relates to Rule 4.1, I think there is no conflict between the standing order and the rule and the facts at issue here. I think the referee correctly found that she violated the rule by taking pictures during a proceeding. The court had gone on the record at that time. It was during a recess. I think that there is no...
You know, I have some trouble with this, counsel. We have a general published rule that she didn't violate, and then we've got this local rule that she apparently did violate. And it strikes me that it strikes me that that's a problem. And maybe the fact she violated the rule is of some significance, but boy, it strikes me as pretty de minimis. Tell me why I'm wrong about that.
The rule violation itself is de minimis. I would suggest that's right, that she, in the sense that it's not the worst thing an attorney has ever done by taking pictures in a courtroom and violating the rule. But I do disagree that there is a disconnect between the standing rule and Rule 4.1, because I think that it is during a hearing. I don't know that that just means when the court is on the bench. The stated purpose for taking those pictures was to create a record of the proceeding, which is in direct contrast to the purpose of the rule, is that the official record is of the transcript.
You know, I was going, as you were arguing this, I was going, just flipping through the general rules, and maybe I just have too much history here, but part of the reason for the general rules of practice was to deal with conflicting local rules. And I frankly think it's a problem that we have a local rule that conflicts with the general rule. And I think this is an issue here in terms of what we do with it.
Well, I think she'd violated the rule itself. I think you can clearly say, as the referee said, it was during a hearing, and that is not limited to just when the judge is on the bench. It includes when the matter has commenced that day, and that is what happened under the facts of this case. I also think the arrest, everyone who has looked at it found probable cause for the arrest, including the federal court in her civil rights action that was recently dismissed as well. I also would like to say that nowhere in the petition or the hearing or the findings is Ms. MacDonald being disciplined for complaining about the fact that she was arrested. That's not the basis of the false statements. That was not the basis of anything. She can complain about being arrested, and she has. That does not form the basis of any of the rule violations. Finally, I think that Justice Dietzen hit the nail on the head when, in this matter, all Ms. MacDonald needed to do was read the court's April order as to the facts and do a diligent inquiry after that. The April 2013 order explained how all of her factual underpinnings that supported her argument that she had argued was based on what her client had said were contrary to what actually had happened in that case prior to her coming on. If she had reviewed that and connected with others, but instead she persisted in claiming all the way through when she was writing those that again, that September 7th order was not the result of an ex parte communication. It wasn't the judge just signing something put in front of him by the opposing party's lawyer. It was the result of an on-the-record hearing where all parties agreed to the conduct and that the order that the court signed was drafted by Ms. Grazzini-Rucky's own attorney. Those are big facts that were explained in April of 2013 and were ignored throughout the remainder of the matter. I would ask that this court affirm the findings and conclusions of the referee as well documented in the record and impose a 90-day suspension followed by 2 years of probation with a mental health component. Thank you.
Thank you, counsel. Thanks to both counsel for the help that you provided to the court in this matter. This case is submitted. We'll issue an opinion in due course. We're going to step off the bench now briefly and reconstitute the court for the next case. So we'll be back in a few minutes.